seated. Now is the time set for oral argument in 1CA TX19-0002 Carter Oil Company, Inc. versus Arizona Department of Revenue. For everybody's information, we are both audio and video recording and live streaming this morning, so that record's out there, as I'm sure most of you know, and we're still doing it. Council, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to preserve any portion of your time, of your 20 minutes for rebuttal, let us know. We will try and avoid taking up all your time and ending your period at the podium. Ultimately, reserving rebuttal time is up to you. We've reviewed the briefs and conference the case this morning, so we are well aware of the facts and issues attendant to the argument. You might want to keep that in mind when you're figuring out what you want to do with your time this morning. Council, when you each come to the podium, I would ask that you state your name and who you represent for the record. And with that, Counsel for the appellant, it's yours.
I'm Scott Teasdale, Assistant Attorney General representing the Arizona Department of Revenue. May it please the court. More than 50 years ago, the legislature created the exemptions at issue. From that time until this claim, no one has ever claimed that fuels used in exempt machinery and equipment were themselves exempt machinery and equipment under the statutes at issue or any of the other exemptions which use the terms machinery or equipment. Fuel is not machinery and equipment under capital castings. Under capital castings, to qualify as machinery and equipment, an item must either be traditionally thought of as machinery and equipment in the industry, or an item not traditionally thought of as machinery and equipment must, quote, function like items traditionally thought to be machinery and equipment.
So how can we step around our Chevron case to get to where you want us to be?
It's very simple. That was lubricants, and this is fuel. Fuel has been dealt with separately in specific applications in this statute. Lubricants have never been separately dealt with. But let's look at what happened in Chevron. In Chevron, if you look at that opinion, they felt that the issue of whether the lubricants were machinery and equipment was a factual issue on which the department had not controverted the expert testimony offered by Chevron. The department did not have an expert. Because they had not controverted that, that basically resolved the machinery and equipment issue. All right? They said there was evidence it was functioning as machinery and equipment. That was unrebutted. Okay, therefore you had a factual record that it was functioning as machinery and equipment. We don't have that here. Once that was determined to be the case, the only issue in Chevron was the application of C1. Under C1, if an item is machinery and equipment under B1 or B2, and it is performing the exempting function, the qualifying function, it does not matter if it is an expendable.
Yeah.
If you do a Venn diagram of machinery and equipment that's exempt and expendables, there will be some crossover, and the lubricants, having been accepted as machinery and equipment, fell into that crossover. Additionally, the opinion cited a TPR from the department interpreting a different statute, which I think right now is at A41, which said that lubricants were deemed to be part of the machine. So that's initially how you distinguish it, but I think we need to get back to the statute and look at what you have to show. You have to show machinery and equipment used directly, and if I may continue.
So your position is that you essentially, in Chevron, did not dispute that the lubricant was machinery or equipment for purposes of that case.
For purposes of that
Even
case,
though-
that's what the court held. I think the department viewed it more as a legal issue, but the courts viewed it as a factual concession,
Well, everyone
if you
knows
look at the opinion.
Lubricants, I mean, the difference between a lubricant and a fuel.
It's very simple. Let's look at definitions of lubricants and fuels. Common dictionary definitions of
Yeah, oh,
lubricants.
I get that. I get they're different, but I
sure.
don't know how they're different under the statute. How we can discern that
Well,
one is a machinery or equipment and one is not.
I'll get there. Very simple.
I'll be quiet.
They're not commonly thought of as machinery and equipment. That's the first thing in the industry. If they had been, they wouldn't have been paying taxes on it for 50 years under the same statutory language. All right? That's number one. Number two, if it's not commonly thought of as machinery and equipment, what do you look at? What does capital casting says? It says, quote, it must, quote, function like items traditionally thought to be machinery or equipment. In Chevron, the court found that these were functioning like items as machinery and equipment based on the fact of failure to rebut certain testimony. We're not doing that here, but let's look at that test, okay? Fuels, matter consumed to generate energy by burning, all right? In this case, what's being burned is the diesel fuel. Is there anything traditionally thought of as machinery and equipment that is burned to generate heat or energy? Energy sources are different. If you have an electric motor in a manufacturing facility, the electricity going into it is not the motor, all right? The motor is exempt machinery and equipment. We're good on that. The electricity is not. If it's gasoline powered, the gasoline is not. If it's diesel, the diesel is not, because there is no equipment that you can find that is being burned to generate the heat and energy, and therefore fuel is not functioning like items traditionally thought of as machinery or equipment.
You referenced the department's interpretation that was cited in Chevron. What relevance now, in view of the amendment to Section 12910E, the administrative review deference? I think it's kind of ironic because it's the Chevron case that's talking about deference, but it's not that Chevron case. My point is, what reference, I mean, do we defer at all to the agency now?
Well, I don't think that, yes. Number one, I don't think that standard applies to the Department of Revenue. I briefed that in a different case. It hasn't been briefed in this case.
Is it exempted from that statute?
That's my understanding, Your Honor, that the Department of Revenue is not covered by the changes to the administrative review statute. I think generally that applies to things in which there was deference on appeal. These appeals are de novo. Okay, so the department rules against somebody down there, goes through the OAH. You get a de novo at the tax court, and then on up to here. So I don't think that the changes to the administrative review statute have any application to appeals out of the Department of Revenue.
Okay.
It was briefed in other cases, and it was not briefed in this case. So I'm sorry, Your Honor, I can't be more specific than that. Additionally, in determining whether something is machinery and equipment, capital castings is actually very illustrative because it looks at whether something functions as machinery and equipment. If you look at paragraph 3 of capital castings factually, it's very clear that all the items exempted were at a minimum touching molten metal as it's being formed into metal grinding balls. Many of the things were performing more functions as well. Moreover, the analysis in capital castings also does not support the notion that diesel fuel is machinery or equipment. Capital casting says that machinery or equipment looks at, whether items physically touch, manipulate, or affect the raw materials or work in process. Right? Everything that they exempted in that case physically touched, manipulated, or affected the work in process, which is the traditional definition of manufacturing. All right? That's, and unlike a chemical that touches the raw materials and at least touches, if not altering it during processing, there's nothing about diesel fuel that does that. It is not modifying or adding value to the raw materials or work in process, as were the items in capital castings.
Would you agree with me? There's the 6 factors that capital casting sets out. And it seems like the first three, essential or necessary, prominence of the item's role in maintaining a harmonious, integrated, synchronized system, and the nexus between the items at issue and the process of converting raw materials. I mean, you have to fuel the vehicles, so those three seem to go on one side, and then the next three seem to cut on your side, which is they don't touch the materials, they don't actually manipulate it, and it doesn't necessarily add value other than efficiency, as opposed to having someone with a sledgehammer there.
It is, in our view, a two-step test. First, you have to determine something's machinery and equipment. But for some unusual things, you have to look at what it does to determine that. Sand, as sold, was not machinery and equipment, but they were using it as components of metal molds, combining it with binders. So essentially, it was a component of something that became equipment. You cross the hurdle, then you get to the used directly tests, where you get into the integrated system, where you look at, is it necessary? If you want to, and to a certain extent, since you have to look at the use, the tests get a little bit blended, but you still have to satisfy both elements of the statute that something is machinery and equipment before you even reach the hurdle of the used directly test. However, yes, is it necessary? Yes, an engine is not going to run without fuel. An electric motor will not run without electricity. So you certainly do cross that hurdle. But let's talk a little bit about necessity and supplies. They did not exempt in capital castings the cement and the lime used for pollution control. All right? Clearly, that's equipment or a supply that is being used. That process, in all probability, the entire plant would have had to shut down without that, because typically you're not doing pollution control without some kind of regulatory requirement. And yet necessity alone did not suffice because it was too far removed from the productive process, even though that productive process probably would have shut down. So we think that's dispositive of the idea that just because something is necessary, and the thing is, look at the statute.
We're still here in a situation in which we got Chevron, which is oil poured into the lubrication tank, is subject to the exemption. But you're arguing is oil poured into the fuel tank is not subject to the exemption. So I don't see how the test that you're just outlining, whether you look first to whether it's equipment and then you look at the thing, it doesn't seem that carries the day here, does it?
If you think fuel is machinery or equipment, it is likely that we should not prevail. The issue is whether fuel is machinery or equipment.
Right, but I'm having the trouble with how is oil poured into one tank machinery or equipment, but not poured into the other tank?
It's different functions. A lubricant reduces friction between surfaces. A fuel is burned to generate energy. And we're told in both capital castings and Duval, you look at the ultimate function to determine whether you're going to exempt something. And the core issue for this court, and the core issue in capital castings, which was responding to direct legislative intervention in the prior case to reverse the prior case, was what is legislative intent? If the legislature exempted fuels as machinery and equipment, when did it do that? Because they don't know, and I don't know. Point out the legislative enactment in which this legislature, which is constitutionally charged with both appropriating funds and raising funds through the taxation system, they don't know that this has been exempted. Okay, we have an exemption that's been around since passed in 1967 when I was born. All right, we have regulations from 1978, so you've got 40 years of regulations, widely known, legislatively acquiesced to, but the legislature created specific exemptions for fuels.
Maybe someone just forgot.
Hundreds of millions of dollars? An oversight?
Lubricants,
you can say, fell through the cracks, nobody thought about it, because frankly, you pile up all the tax dollars on lubricants that are going into bulldozers and mines, and the amount of tax is not going to make anyone lose sleep.
Isn't
$100 million plus refund exposure, and I'd say that's probably a dramatic understatement, because if you're exempting fuels as machinery and equipment, why is it not exempt machinery and equipment for electrical generation? The dollar amount of use tax and TPT on fuel and natural gas burned in exempt generation equipment under B4 will boggle the mind if that hits. Okay, this court may want to think twice before it blows a incalculable hole through the state budget based simply on a case like Chevron, in which the department treated something as a legal issue, which the court treated as a factual concession.
Isn't your best argument the numerous times, and your brief cites them, where our tax code specifically treats fuel, diesel and non-diesel, and di-diesel, non-diesel, in a lot of other situations.
That's
And-
exactly right, Your Honor. Every time they've exempted fuel, the legislature has specifically acted to do that. All right? Why would they have enacted the conditional TPT exemption for coal sold in this state, which was targeted to try to keep the Navajo power station open, which is not happening apparently, so it's never gone into effect. All right? It was conditional on the sale of that plant and the continued operation of that plant. They had to do that to try to create an incentive which did not exist. When they created the exemption for qualified environmental technology facilities, they exempted a lot of fuels and energies that were used to generate power for those facilities or were used in manufacturing. All right? If fuel used in manufacturing was exempt, why would they have had to do that? Because that exemption's been around since 1968. They had to do it because it wasn't exempt. And the fact that you have these specific exemptions clearly shows, in our view, that the legislature has never contemplated, when they use the word equipment, that they need that's going to encompass everything that's used in the equipment. You have the same thing in airplanes. We have exemptions for airplanes and accessories and related equipment in the tax code. But there's a separate exemption for airplane fuel, not a complete exemption. You pay tax on a certain amount, then over a certain amount, you don't. But again, if equipment encompasses fuels, that would not have to be there.
What about
And again, this
electricity?
is an issue of first impression, largely triggered, I think, by Chevron. They initially came in and said, well, this fuel has a lubricant capacity as it's being used as fuel, lubricates fuel pumps and fuel injectors. Still a fuel, okay? Chevron with Techron, it's got detergent additives. You're still buying gasoline, and it's the same thing here. You know, fuel has to meet a certain chemistry in order to work in a machine. It's still fuel.
Am I right, though, that there's nothing, and it seems clear from the record, but we did some outside research to see if we could find anything. Dyed diesel fuel is just diesel fuel with dye in it. It's the dyed diesel we're talking about here, they haven't added a specific lubricant to it or something that makes it more viscous or something than diesel you'd buy at a gas station.
The record was this. Diesel fuel naturally, as refined, has the physical characteristic that it lubricates the fuel pumps adequately. When they went to ultra-low sulfur diesel fuel, which is what all the diesel fuel is now, sometimes during refining, that process of taking the sulfur out removes the chemical substances that cause the lubricity. So they may add the lubricity additives, but you don't know in a particular batch whether they did or they didn't.
But I'm saying between dyed diesel and
Exactly.
regular diesel, so diesel subject to the
Yes,
fuel excise tax.
diesel number 2 is diesel number 2. The dye is there for fuel tax issues.
Okay.
Over the road, when you buy fuel for road use, you have a per gallon tax, and it's not subject to the transaction privilege tax. When you buy diesel fuel for off-road use, federal law requires it be dyed, so you can make sure it's not ending up in road use. If an over-the-road trucker has red dye on their on the thing where you put diesel fuel in, they're going to get in trouble on the fuel tax. But yeah, the dyed issue is just a matter of whether it's going to be subject to the transaction privilege tax, because there's an express exemption for fuels that are subject to the per gallon tax for roads, which only applies to fuels used for road transportation. I'm going to reserve a couple of minutes if I can.
Thank you.
Brought a picture. Good morning.
Were these pictures admitted in the record below?
Yes, they are. They are at Index of Record 33, Part 5 of the Department of Revenue Statement of Facts. in support of the Department of Revenue's motion for summary judgment. These were produced and the department included it in its statement of facts. Good morning. I'm Brian LaCourte of Ballard Spahr. I'm joined by Chase Bales of Ballard Spahr and James Busby of the Kavanaugh firm. We represent the appellee Carter Oil. May it please the court. This case involves a long history, or at least a statute that has been the subject of a long history of case law, of stare decisis. The statute has two tests, but those two factors in that test have been substantially considered by this court in at least 4 decisions, and by our Arizona Supreme Court in capital castings. Stare decisis is an important point, as we raised in our briefs. There seems to be a denialism by the Department of Revenue as it relates to Chevron, and this court's more recent decision in Empire Southwest of not dealing with inconvenient common law decisions. Chevron is good law. Chevron was not petitioned for review to the Supreme Court by the Department of Revenue. Chevron applies to this case. So I'm going to speak to the 2-part test, and in particular Chevron, and we think Empire Southwest as well, as guided by the stare decisis in capital castings and Duval C.
Before you get too far, Empire Southwest dealt with whether a truck, undisputably machinery or equipment, was integral to the process. So why is Empire Southwest relevant to you at all?
It's a fair question, and Chevron more directly applies, or is more directly analogous than Empire Southwest. Judge
Okay.
Morris, I agree. But what this court did in Empire Southwest.
But our issue here is fuel, machinery, or equipment, right?
Well, it's not entirely clear to us, which is why we briefed the second part of the test used directly in, because it appears to us the department is challenging both fuel as machinery and equipment and challenging Chevron's consideration of that issue, which was more than just a concession of a fact. I'll deal with that in a moment. And secondly, the department seems to suggest that fuel in machinery and equipment is not necessarily used directly in mining, because the fuel is in the machinery and equipment. It's not physically touching or somehow engaged in the direct use. So as we brought this chart to show, there's no question that the equipment at issue is mining equipment or processing equipment. There's a hauler, a loader, a dozer, and a crusher. And this is directly used in the mining operations in Clarkdale, Arizona, that is conducted by Hanson Aggregates as supplied by Carter Oil. That's the second part of the test. The first part of the test as to machinery and equipment goes to the very questions raised by the panel to Mr. Teasdale. In Chevron, the definition of machinery and equipment was considered in the broad context of our stare decisis, of capital castings, recognizing that these are to be flexibly, or to use flexible definitions of those terms, to give effect to the legislative purpose that this is to encourage economic development in mining.
But doesn't that encompass everything that a mine uses, really? I mean, that we want to encourage mining, well, then pay for the sandwiches the men eat on overtime.
Hey, that was
you know?
my example.
It was a good one, though.
The old sandwich example. So, Judge Johnson, I would respond this way. There are a number of items related to mining or manufacturing processing that is not exempt. What we are dealing with here is a specifically identified set of equipment that unquestionably is in the open pit mine in Clarkdale, is touching the ore, the earth, the material, and is crushing it and processing it. There are, for example, at this mine, the concrete mixer trucks that distribute the aggregate concrete or asphalt for installation on our roads and highways. That's not tax exempt. That's the output. That's the distribution. The actual equipment, and that uses diesel fuel, but it is not exempt. It is certainly overall.
Do you use dyed diesel or regular diesel?
It uses regular street legal diesel.
So it would be subject to the excise tax, which is not subject to the exemption anyway.
Correct, but even there are instances where there is equipment at the mine, as testified by the mine manager below when Mr. Teasdale deposed him, Jay Parker, who testified that there is a pickup truck that uses red-dye diesel fuel because it's not street legal to circulate the exterior of the open pit and review the mining operations. That's not tax-exempt equipment, even though it uses red-dye diesel fuel. So there are a host of other equipment. So as the Capital Castings Court noted, a computer in an office is not tax exempt necessarily. A computer that drives a manufacturing process in the line may be tax exempt. So there are items that in some instances at this facility are not tax exempt and some that are. But this case is really narrowed, and it's that same index of record site, Index of Record 33. This case is narrowed to these 4 pieces of equipment and the red-dye diesel fuel used in this equipment, which is unquestionably machinery and equipment used directly in mining, meaning both elements of the statutory test. So what Mr. Teasdale was talking about in Chevron not applying, or fuel being different from oils, greases, and lubricants, is meritless. Chevron does apply.
That's a very definitive term, say meritless, because it does seem like the legislature knows the difference between fuel and machinery and equipment. And so, for example, in the statute where it says we exempt machinery and equipment used in electrical generation, the legislature in just the next section down, same statute says, and we're also going to exempt fuel used in electrical generation. So why would we not think that the legislature, if they'd intended to exempt fuel in this case as part of a machinery or equipment exemption, wouldn't have said so explicitly?
Here's the reason why. The legislature did not list or identify oils and greases as exempt, even though oils and greases are taxed at retail and may be taxed at retail for a number of uses. But in this context, they are exempt. What the legislature did do, Your Honor, is in 1999, it amended C1, and it made very clear, relating back to Duval-Ciarita, that expendables, regardless of the useful life, that are otherwise exempt in B1 and B2 are taxed, but otherwise exempt in B1 or B2 is the important part of that legislation. The legislature did not have to list or identify every expendable, nor did it choose to. There's any number of instances where one particular broad item sold at retail may be exempt in a particular exemption, but otherwise taxed at retail. The legislature here, as recognized by Capital Castings, which made this crystal clear, sought to expand and be flexible with the materials that are used in mining and metallurgical processes and manufacturing. And interestingly, it defines mining and metallurgical processes. It does not define machinery or equipment. It left that to its breadth and extent. So the legislature actually has already spoken on this. The legislature has said, we want this to be broad. We want to use the integrated rule test from Duval-Ciarita. And that was in response to the Court of Appeals decisions in Capital Castings. So it was not without purpose. And so my response would be, yes, of course, the legislature is using a broad term without providing a parts list. It doesn't say hoses. It doesn't say belts. It doesn't say steam pipes. It doesn't say silica sand. The reason is that there are any number of items that may be machinery and equipment under this broad definition that are used directly in mining or metallurgical processes.
The tests were bound to apply from above, by meaning the fourth floor, not higher than that, is traditionally thought of as machinery or equipment, or has a function equivalent to what machinery or equipment traditionally performs, correct?
Correct, but I think
how does fuel fit in that, either of those two standards? And give me a case that has said anywhere that fuel, machinery or equipment includes fuel.
Okay, the first part of your question, the ultimate function test, as we read it in Capital Castings, is to address this point in time issue. So the question is, what is its ultimate function? when it's deployed in the process, rather than sitting on the shelf, rather than ordered out of the catalog, or in this instance, on the internet, or through a services contract, what is the ultimate function? So if I can just spend one moment on that, the ultimate function of fuel is to operate within the system of this equipment, which was the very standard that this court set out in Chevron. It said the oil and greases are machinery and equipment, particularly in the context of being used within the system of admittedly exempt equipment. And incidentally, in Chevron, it was very similar, if not identical, equipment. It was loaders and haulers and dozers. So we know from this court's decision in Chevron that oils and greases used in the systems that are admittedly exempt is exempt. The same applies, so too, with red-dyed diesel fuel. Now, in terms of the ultimate function, that is the ultimate function. If the pickup truck at the mine that is not exempt uses red-dyed diesel fuel, its ultimate function is non-exempt. The red-dyed diesel fuel used here is exempt.
When you have an open pit copper mine, you've got those haulage trucks running around and around and around. If they are powered by ordinary gasoline, is the gasoline exempt under your theory?
Yes. In other words, if it's
the lubricating nature of diesel is irrelevant.
No, it's not irrelevant. It's relevant because that is what is at issue in this case.
But the logic you would have us employ would say gasoline and
Electricity.
if you have electric vehicles, or machinery that plugs in instead of is powered by diesel.
Electricity is a whole different
Runs your
ballgame.
smelter, turns on your
Because
lights.
it's regulated, it's a different classification, it's regulated through the Arizona Corporation Commission, there are rate-making issues, it's not sold at retail.
Okay.
This is still a retail sales tax exemption. So
Let's go back
electricity
to my
is,
sandwiches then. So if you,
I apologize, I didn't get to the sandwiches.
next case, we issue a decision in your favor. In the next case, the caterer says, look, these guys have to eat or they can't operate those machines. And you can see there's spaces in those machines for human beings to be in there. So I want the exemption to apply to the sandwiches that they need. And we'd have to say yes to that too, wouldn't we?
I disagree. I don't think sandwiches would be exempt under this. I think the machinery or equipment definition has to be under both Chevron and cases
But
before
you
it,
just told me
including
earlier, it's part of the system. So once we put it into that system and you close those doors on those loaders, they're inside that vehicle. So what's the difference?
Well, I think a human-consumed sandwich is not the red-dyed diesel fuel that is placed in this system. I think the better analogy is to Chevron, not to the catering truck. And if a message were to be delivered to an operator because the two-way radio or cell phone is not working, the piece of paper that the message is written on from the foreman is not machinery equipment. There are clear guidelines from this court's body of stare decisis that defines machinery and equipment.
Are we bound to follow Chevron?
I believe it's a principle of stare decisis that this court should follow its precedent. This court followed Chevron a year ago in Empire Southwest. This court should follow Chevron.
That was a truck. That was a truck. It wasn't some liquid.
It was a truck, but you did consider
Okay.
the prior precedent.
I see your argument, and I see how the statute might be read to allow that, particularly under the Chevron case. But how do we disregard the fact that the tax code specifically speaks to fuel exemptions over and over and over again, expressly, and no such reference to fuel is found in these exemptions? How do we deal with that? Because you're asking for a lot here, and that's a tough haul for me.
Sure. I'd answer it this way, Judge Johnson. And we briefed this. The Arizona Supreme Court disagreed with this court's capital castings Roman numeral 2 decision. And in capital castings, the Supreme Court's capital castings, the higher court emphasized that this court's more narrow interpretation of the exemption, particularly in light of the legislative amendment that the legislature was attempting to make certain that this was given the broad treatment to effectuate purpose. The Supreme Court said the capital castings 2 failed to give full effect to the legislature's intent. That's capital castings 207 areas at 449. In reaching that conclusion, the Supreme Court made it clear that the legislature meant to alter the specific result reached by the Court of Appeals in the more cramped interpretation of the statute, which was, in effect, this isn't really stated, so we're not going to go that far. They don't say silica sand in the statute. On your point, Judge Johnson, that there is treatment of fuel in different parts of the statute, that may be true, but this exemption relates to the specific industry of mining, metallurgical processing, and manufacturing. And the legislature chose a broad exemption here without an article of index for every conceivable piece of machinery and equipment. And the Supreme Court has noted that that means something. As I said before, the legislature did define mining and metallurgical processes in this statute. It did not define machinery and equipment, and it has had a chance to do so year in and year out. To Mr. Teasdale's point that no one in 50 years decided to raise this, well, Chevron was decided in 2015. No one in 46 years decided to raise oils and lubricants. And in the early 2000s, in the capital castings line of cases, sand and various mold washes were not raised in the past. And this body of case law has evolved significantly over the last 10 to 15 years. So we have guidance now. That's why these decisions, and your question, Judge Morse, on following Chevron, stare decisis means something. That's how we conform to the case law for our professional endeavors as citizens and corporate actors. And so the idea that this decision gives that effect should not be.
Reliance interest. So one of the principles of stare decisis, and one of the things we are instructed to follow, is because of reliance interests that people have in decisions, what you just alluded to. What's the reliance interest here?
Well, I think the reliance interest is that, and I want to speak to the size of the refund because that is sharply in dispute.
That doesn't move me at all, so don't waste all the time.
So the school funding cases may have had a point in the financial impact. It's not here, and it's gross speculation. But putting that aside for one moment, the reliance here is that machinery and equipment in mining or manufacturing over time is going to evolve. The idea that a piece of equipment might operate on a certain with a computer chip was unknown 25 years ago. It is now current. There's technology that develops, and so the reliance on the statute is the legislature keeps it broad so that these interests can be served. And this equipment can be nimble.
This isn't an evolution thing. They've been using diesel fuel since 1920s, I think. I'm making that up. I have no idea, but a long time. So, what? Let's move on from that.
Okay.
I've got a question before you go on
Okay.
something else.
I have one more. I had asked earlier. Is there any case in any jurisdiction in which someone has said, or which a court has said, machinery or equipment includes gasoline or diesel fuel?
No, but the other jurisdictions don't have this type of exemption, and so the point is.
Is there anything like in the Bureau of Mines guidance that says, hey, includes the machinery or equipment includes the fuel used to power the machinery or equipment?
Well, I would say the department's regulation that Mr. Teasdale mentioned includes window washer fluid as part of the equipment. And so if window washer fluid is part of the equipment, which isn't certainly essential to the use of the equipment, as the Chevron court noted oils and lubricants have to be able to see. Well, it stands to reason that the central ingredient that powers the equipment and also provides lubricity to the inner parts of the engine is part of the equipment.
What about application of 910E Deference or no?
No deference. We flatly disagree with Mr. Teasdale's remark that the decision and amendment has no bearing on the Department of Revenue. We just contest that. We think there is no deference, particularly in light of the fact that this court has acted independently of the department's regulations in making its decisions. The Chevron decision only notes as an afterthought at the end of the decision that its decision is consistent with some of the department's thinking behind that regulation. It's not deference, and it is by no means a reliance on how the department interpreted it.
And I'm not sure that the statute had been amended, the review statute had been amended by the time that we issued Chevron. Check that out.
I agree. I think this is a more current issue, but there is no deference owed to the department's regulations.
Thank you, counsel.
Thank you, Your Honors. I appreciate it.
A few quick points. Fuels are an issue of first impression. The idea that stare decisis applies is, it simply doesn't. Additionally, essentially they're arguing, in effect, something like offensive collateral estoppel against the state, and that doesn't work against the state. Let's see. I do get weary hearing the horrors that the department ignores what's coming down from the court. The department issues millions of tax refunds every year. The ones you see, you're looking through a straw, and then they come in and act as though the department is an ogre. Okay, if you overpay, you get your money back. If it's an issue we don't agree with, we end up here. But that is not reflective of the department ignoring case law. The department applies the integrated system rule and has for quite a long time. These cases are not ignored. As you know, there's no specific exemptions for lubricants. There are specific exemptions for fuels. Under the plaintiff's theory, essentially, only things that are unnecessary to the process are not exempt. So therefore, everything that's necessary is exempt. That's straying, it's a bridge too far, straying too far away from the statute. Exemptions and deductions in this state, and in every state I'm aware of, and at the federal level, are narrowly construed against exemption. And that is still the law in this state, and Capital Castings reiterated that point, but just said you don't want to get too narrow, which is fine. That's perfectly reasonable, but they're still narrowly construed. Capital Castings, again, still just exempted things that were clearly functioning as machinery and equipment. With regard to the question of other states interpreting machinery and equipment to encompass the fuel used in them, virtually every state with a sales tax has an exemption for manufacturing equipment. All right, all the states want to have manufacturing located to be competitive. Most states have those. I'm not aware of any case that's interpreted fuels as machinery and equipment in any of those states. Every statute I've seen where fuels are exempted from a state sales tax either expressly mentions fuels or they exempt all consumables used in manufacturing, which would encompass fuels. The legislature has not chosen to do that. Maybe they should. They should go down to the legislature and say, we need this for our competitiveness. That's the way we have. I printed out the 425061, ran 14 pages, almost all exemptions. All right, the legislature knows how to create exemptions, and they respond to constituent inquiries. The fact that they haven't speaks volumes when you look at how many exemptions they have enacted.
Have you got any more of an explanation for why 12910E doesn't apply to the Department of Revenue?
I would have to brief it, Your Honor. It hasn't been briefed in this case. So,
Well, that's true.
if you would like supplemental briefing, I can do a 2-page brief.
We're out of time, folks.
Thank you.
We always learn. Thank you for the argument today. We have all enjoyed this time. We're going to take the matter under advisement this time, and we'll issue a decision in due course. Thank you.